My name is Natalia Bulat. I work as an associate professor at the Department of Civil Disciplines at Odessa Mechnikov National University, and I would like to present the topic Computer-Generated Objects Protection, focus on the Ukrainian copyright law. The possibilities AI demonstrates even for now impress. For example, on this slide you can see 3 pictures. 2 of them were created by a famous painter Rembrandt, while one of the images was computer-generated. And if you try to guess which one is computer-generated, it is very difficult to decide, because all of the pictures use the same style, they use more or less similar colors. Actually, the first one was computer-generated, while the second and the third ones were human-created. But once again, I would like to emphasize that it is very difficult to decide. The possibilities AI demonstrates, as well as the popularity of generative AI, lead to questions in intellectual property law. On this slide, you can see an image of a kitten which was computer-generated, and the questions in intellectual property law are the following. Is it necessary to provide this picture with legal protection? What kind of protection is needed? Is it more reasonable to put this picture in the public domain? While mostly answering this question are in the focus of a doctrine, there are some legislative frontrunners that have adopted their legislations to the new reality. For example, the UK, Ireland, Hong Kong and New Zealand protect computer-generated works with copyrights. Along with that, another approach is discussed in a doctrine: protection of computer-generated objects with sui generis rights. This approach was implemented in Ukraine, and this approach will be the center of our attention today. I have divided my presentation into 3 sections. First, I will provide the general overview about legal protection of computer-generated objects in Ukraine. Then I will address in details the question of meaning and scope of non-original computer-generated objects. And finally, I will discuss the question of who is the holder of rights to computer-generated objects in Ukraine. Let's start with the first issue with a general overview. But before going into details regarding protection of computer-generated objects, let me say a few words about copyright law generally. Copyright law protects literary, scientific and artistic works. Works covered by copyright range from books, music, paintings, sculpture, films and applied art to computer programs, databases and technical drawings. This slide illustrates some examples of what can be copyrightable. Music compositions with and without lyrics, choreographic works, books, paintings, works of applied art, and of course the list is not exhausted. Concerning the international and national legal framework, in copyright law, it is worth mentioning at the international level the Berne Convention, the WIPO Copyright Treaty, and the Marrakesh Treaty. At the national level, it is worth mentioning the Civil Code of Ukraine and the Law of Ukraine on Copyright and Related Rights. It is necessary to understand that copyright protection extends only to expressions and not to ideas, procedures, methods of operation, or mathematical concepts as such. Imagine that you have an idea how to write a novel or short story or a poem or whatever else about a young man and a woman falling in love despite family and castle obstacles. This is just an idea, and copyright law cannot protect it. To have an object protected, you need to express your idea. For example, you need to open your laptop and to write a novel about a young man and a woman falling in love despite family and castle obstacles. In this case, you will have a novel, an object which will be protected by copyright law. However, even in this case, the idea itself will still not be protectable. And it means that another person can use the same idea and can write another novel or a short story or a poem or whatever else about a young man and a woman falling in love despite family and castle obstacles. And if you ask yourself how many books you have read about a young man and a woman falling in love despite family and castle obstacles, I think many. Another example, imagine that you have an idea how to draw sunset over the sea. Once again, this is just an idea and copyright law cannot protect it. To have an object protected, you need to express your idea. For example, you need to take a piece of paper and to draw the sunset over the sea. And in this case, you will have the picture, an object which will be copyrightable. However, even in this case, the idea itself will not be protected. and another person can draw another sunset over the sea, and this object will also be protected. This slide illustrates how different painters expressed the same idea, sunset over the sea. And of course, the list can never be exhausted. And you also have an option to add another expression of the very idea. This was mentioning that in copyright law, the term work is used in a very strict sense. It can be applied only to objects which meet copyrightability criteria. In other words, the term work is narrower than the term object. An object, to be considered a work and to be copyrightable, shall satisfy two criteria. The first one, objective form, written, tangible, electronic, digital, etc. And the second one, originality. The meaning of originality differs from country to country, from jurisdiction to jurisdiction, but generally, originality means that a work shall be a result of not only intellectual, but also creative activity. Let's turn back to the slide illustrating how the same idea can be expressed in different ways. As I have mentioned before, this list can never be exhausted, and what is important, an author is free in his choices, in his decisions. And taking into account this freedom, and also bearing in mind that there are unlimited number of options of how to express this idea, we can conclude that drawing sunset over the sea requires not only intellectual but also creative efforts. And that's why the result will be considered original and copyrightable. However, there are cases when the creator is under the pressure of different factors. Imagine that you need to create a classes timetable. In this case, you should take into account students' workload and the list of classes mandatory for each student, lectures workload. You should understand that a good classes timetable is a timetable without windows. And finally, you should take into account rooms availability. And all these factors put pressure on you. And if you ask yourself how many options do you have to create a really good classes timetable? In fact, a few. And taking these limitations into account, and also bearing in mind that the creator is under the pressure of different factors, we can conclude that a classes timetable cannot be considered original and therefore cannot be copyrightable. As I have mentioned before, the meaning of originality depends on a particular jurisdiction. However, in very general words, we can conclude that in countries belonging to common law tradition, very little is required other than that a work must not be a copy of another work, and an author should have displayed a minimum amount of skill, labor, and judgment in making it. In contrast, in countries belonging to civil law tradition, the criterion of originality is usually stronger. A work must bear the stamp of the author's personality. A creative effort would be required from the author that may go beyond mere skill, labor, or judgment. Take into account the general considerations about copyright law and especially the considerations about originality standard. Let's go on and let's now focus on how Ukrainian legislation protects computer-generated objects. This was mentioning that the law of Ukraine on copyright and related rights was passed on 1 December 2022 and has been in effect since 1 January 2023. This law replaced the previous law of Ukraine on copyright and related rights of 23 December 1993. The new law of Ukraine on copyright and related rights is the first attempt in the Ukrainian legislation to regulate relations in the field of computer-generated objects. Article 33 of the law of Ukraine on copyright and related rights establishes a non-original object generated by a computer program is an object which differs from existing similar objects and was created as the result of functioning of the computer program without direct participation of a natural person in the object creation. Works created by natural persons with using computer technologies are not considered to be non-original objects generated by a computer program. Now, I would like to pay attention to some terminology remarks used in the legislation. First, the legislation uses the term of a non-original object, neither extending the meaning of originality nor establishing the picture that a computer-generated object is original. In this context, the legislation is quite accurate with using the terms of objects and works. When it speaks about non-original objects, it calls them objects. When it deals with original human creations, it refers to them as works. Such an approach differs from that implemented in the UK and from those implemented in some other jurisdictions belonging to common law tradition. For example, in the UK, computer-generated in relation to a work means that the work is generated by a computer in circumstances such there is no human author of the work. The author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. As you can see from this slide, the UK legislation uses the terms of work and an author in relation to computer-generated objects. Such an approach reflects so-called skill and labor doctrine, which was used in the UK for the interpretation of the meaning of originality. According to this doctrine, originality was interpreted in a more economical way, without requirements of personality expression. However, it is worth mentioning that the skill and labor doctrine in the UK was replaced by the case law of the EU. And the case law of the EU uses a subjective approach to originality. I will refer to this approach a little bit later, but now I would like to emphasize that the UK legislation in relation to computer-generated objects uses a fiction. It calls computer-generated objects works, although in fact they do not meet originality. Concerning the possibility of such an approach implementation in the Ukrainian law, it is worth mentioning that Ukraine traditionally belongs to countries of draw-debtor system. And while some countries of copyright system, which is usually applied in jurisdictions belonging to common law tradition, can protect computer-generated objects with copyrights, countries of draw-debtor system, which is usually applied in jurisdictions belonging to civil law tradition, are hardly suitable to use the same methodology. Although the meaning of originality may differ from country to country and there are some deviations inside of the draw-debtor system, usually originality here is interpreted in a very subjective way. Such an approach was also used in the EU practice, which moved from just the author's own intellectual creation, a kind of compromise between draw-debtor system and copyright system, to the necessity of free and creative choices, which are not dictated by technical considerations, rules, or constraints, which leave no room for creative freedom, by which an author can stamp the work created with his personal touch. From the perspective of such a subjective approach, even the words combination computer-generated work is an oxymoron. If an object is a work, then it is original, and then it cannot be generated. Probably it can be created with using computer technologies. If an object is generated, then it is not a work, because it is not original. Thus, using the terms of objects and works in Ukrainian legislation seems reasonable. Another terminology remark is that the Ukrainian legislation does not use the term of AI. Instead of it, it uses broader concepts, such as computer programs and computer technologies. And this also seems reasonable, because not only AI software can allow new objects creation or generation. Have you ever tried creating such objects? I have, and it's really fun. So, if you would like to have an avatar, usually mobile applications will provide you with at least two solutions. The first option is to select elements of your future avatar. You can select skin color, face shape, lips, eyes, hairstyle, clothes, etc. The second option, you can just click one or several buttons and have an avatar generated. For example, in this case, I needed to select a gender, and then a mobile application by randomized choices generated an avatar for me. In both cases, AI technologies are not mandatory, and even non-AI software can allow such object generation. And of course, there is no doubt that using such non-AI software as, for example, Microsoft Office software, we can create a work. We can write, for example, a short story which will be copyrightable. Therefore, using the terms of computer programs and computer technologies instead of AI seems reasonable. To sum up, Article 33 of the Law of Ukraine on Copyright and Related Rights divides objects into two categories: works created with using computer technologies, which are protected under general copyright law regime with moral and economic rights, and non-original objects generated by a computer program, which are also protected in Ukraine. They are protected with sui generis rights. As it is known, sui generis from Latin means of its own kind or class. Usually, sui generis rights are designed in intellectual property law to protect so-called non-conventional objects, which cannot be protected within the existing tools. It is worth mentioning that the introduction of sui generis rights to non-original computer-generated objects has been discussing in a doctrine. Usually, doctrinal proposals discuss exclusion of moral rights protection and providing shorter period of economic rights protection. The Ukrainian legislation is in line with these two tendencies. First, sui generis rights do not include moral rights. They include only economic rights. Second, these economic rights have shorter period of protection than usually. They are protected only during 25 years from the 1st January the next year after an object was generated. According to the Article 33 of the Law of Ukraine on Copyright and Related Rights, the sui generis right to a non-original computer-generated object arises as a result of the fact of generating this object and comes into effect from the moment of its generation. As a condition of obtaining the sui generis rights, the legislation quite clearly establishes the necessity of observation of intellectual property rights or sui generis rights to the objects used for generating the new non-original object. Along with that, non-original computer-generated objects can be used free under general rules. Sui generis rights are transferable and protectable. To sum up, sui generis rights to non-original objects are equaled with economic rights to works, however with shorter period of protection. And to understand the content of sui generis rights, we need to refer to the content of economic rights to works. According to the Law of Ukraine on Copyright and Related Rights, the subject of copyright has the right to use the work in any ways, as well as the exclusive right to allow or prohibit the use of the work by other persons. Therefore, sui generis rights means the right to use the object in any ways, as well as the exclusive right to allow or prohibit the use of the object by other persons. If we compare the approach implemented in Ukraine with that implemented in the UK, we can conclude that although these approaches have some conceptual differences, I mean using the term of works in the UK and the term of objects in Ukraine, in practice these two approaches are quite similar. Both exclude moral rights protection and provide shorter period of economic rights protection. In the UK, economic rights to works are protected during 50 years from the end of the calendar year in which the work was made. In Ukraine, sui generis rights, which means economic rights, are protected during 25 years from the 1st January the next year after an object was generated. So, besides some conceptual differences, the UK's and Ukraine's approaches are quite similar in practice. As I have mentioned before, as a condition of obtaining the sui generis rights, the legislation establishes the necessity of observation of intellectual property rights or sui generis rights to the objects used for generating the new non-original object. Let's look at how this condition is constructed in the legislation. According to the Article 33.7 of the Law of Ukraine on Copyright and Related Rights, if a non-original object generated by a computer program is the result of the use of copyright and/or related rights objects, The relevant subject shall enjoy sui generis right to such a non-original object, provided that the subject observes the copyrights or related rights to works, or related rights objects used in the process of generating such a non-original object. The same necessity is established with regard to other non-original computer-generated objects. If a non-original object generated by a computer program is the result of the use of another protected non-original object generated by a computer program, the relevant subject shall enjoy sui generis right to this object, provided that the subject observes the rights to the non-original object generated by a computer program which was used in the process of generating the new non-original object. Let's assume that the picture of a cat you can see on the right side of the slide was generated as a result of using the pictures of cats you can see on the left side of the slide. In this case, in order to have the picture on the right side protected with sui generis rights, you need to observe the rights to pictures you can see on the left side of the slide. In other words, there are no exceptions or limitations in the Ukrainian copyright legislation concerning using data for training AI or prompt submission. And if you need to use some objects to train AI or to submit prompts, you need to observe the rights to such objects. And it doesn't matter whether these objects are copyrighted works or whether they are non-original computer-generated objects. In both cases, you need to observe the rights to these objects because this is a condition to have an output protected. Let's sum up. Non-original computer-generated objects are protected in Ukraine with sui generis rights. Sui generis rights include only economic rights and do not include moral rights. Sui generis rights have shorter period of protection, only 25 years from the 1st January the next year after an object was generated. The sui generis right arises as a result of the fact of generating the object and comes into effect from the moment of its generation. As a condition of obtaining the sui generis rights, the legislation establishes the necessity of observation of intellectual property rights, a sui generis rights to the objects used for generating the new non-original object. Along with that, non-original computer-generated objects can be used free under general rules. Sui generis rights are transferable and protectable. Let's go on and let's now focus on the meaning and scope of non-original computer-generated objects. Once again, Article 33 of the Law of Ukraine on Copyright and Related Rights divides objects into two categories: works created using computer technologies, which are protected under general rules, and non-original objects generated by a computer program, which are protected with sui generis rights. And now we'll focus on the latter category. On the left side of the slide, you can see the legal definition of a non-original object generated by a computer program. I have already referred to this definition, but let me remind that a non-original object generated by a computer program is an object which differs from existing similar objects and was created as a result of functioning of the computer program without direct participation of a natural person in the object creation. From this definition, we can conclude that a non-original object generated by a computer program shall satisfy two criteria. First, it shall differ from existing similar objects, and second, it shall be created as a result of functioning of the computer program without direct participation of a natural person in the object creation. Let's start with the second criterion. This criterion is crucial for dividing objects into two categories: works created using computer technologies which are copyrightable, and non-original computer-generated objects. In other words, the proper understanding of this criterion can be helpful in treating a particular object and making a decision whether it should be related to works and be copyrightable, or whether it should be related to non-original computer-generated objects. The key question here is how to interpret the words combination without direct participation. The recent research proposed at least two solutions. The first one is to assume that without direct participation means without any human participation. And non-original computer-generated objects mean only objects generated fully automatically. However, it is worth mentioning that we don't have such objects, at least for now. And at least minimum human participation is always required. Taking this into account, there is another approach of how to understand without direct participation. According to this approach, it means participation in the preparation state, but without influence on the output. Such an approach seems more reasonable, because only this approach can allow the application of the Article 33 of the Law of Ukrainian Copyright and Related Rights. If we have protection of non-original computer-generated objects, then it is worth assuming that we need such objects for now. Further, the legislation literally excludes only direct, not any participation. And the question here is what participation is direct and what participation is indirect. In other words, how broad the understanding of without direct participation should be. This question leads to originality issue. The Law of Ukraine on Copyright and Related Rights contains the legal definition of originality. According to it, originality of a work is a feature, criterion, which characterizes a work as a result of own intellectual creative activity of an author and expresses creative decisions made by the author during creating the work. This approach is in line with the approach used in countries belonging to civil law tradition. And this approach is also used in the EU case law. According to which, as I have mentioned before, a subject matter, in order to be considered original, shall express the author's personality as the result of his free and creative choices. Here, I would like to emphasize 2 points. First, originality criterion requires author's creative decisions contributing to the work creation. Second, an author is a natural person who created a work with his creative efforts. Taking into account such a subjective approach to originality, there is a question whether an AI output can be original at all. There is no doubt that using such non-AI software as, for example, Microsoft Office software, we can invest creativity and we can create a work created with using computer technologies. However, what is in case of using AI, where our opportunities to influence the output are limited?